Okay, you guys, the situation that's gonna happen. Welcome back to another live. The state want to argue with the judge about the state want to argument about a situation that happened to one of the defendant in this case that said that they didn't want to talk no more. They wanted to talk to their attorney, in which they should always have a if they say they want to talk to their attorney, ain't nothing else you can argue with. And I noticed something since the state is very argumentative. They are very argumentative for some reason. I don't know what's going on, but let's listen to this.
Um, I've had an opportunity to take a look at the
This is a Young Thug case.
and consider the motion to suppress statements of defendant Demontre Kendrick, and also to take a look at the state's response in respect to those particular assertions in terms of the for Jackson Daniel hearing, which the court has to make those determinations in voluntariness thereof. What was the last thing you heard, Christina? The court has to take into account to determine the voluntariness of statement. In such, I have considered as well, and will be admitted for purposes of the motion to suppress Jackson Dental hearing states 1 and 2, Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more.
See,
and at the second video,
when he said, I need to talk to my lawyer, I do not need to talk to no boy, need to be considerate that he don't want to talk anymore. Y'all can't make this man talk no more. Nothing should be going beyond what he said. Now watch this. Watch what this turned into. Now watch what she says.
Starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Here she go. And look, let me tell y'all something. Now, I'm not biased at all. But I noticed that the state doesn't listen. She doesn't listen at all to me. She wants to get whatever she has to say out of her mouth. But she's not listening to what's going on. And I noticed that with her. This is Fannie Willis' woman. One of the women that working with her in this case. They want to dish you. They want to put their information out there, but they don't want to listen. She doesn't, the state doesn't want to listen to nothing of what you're trying to say. They are trying to put these boys behind the bars for something that already been acquitted. Listen. And she don't listen.
My ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
We have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had.
So recently, I
See, my
realized
thing
that
is,
I lack someone
if
special in
that's
my life.
the
Let's be real,
judge
the
is
dating
the
apps,
judge,
well, they weren't
and
exactly
you're
working out. The conversations were dull as
the
hell.
judge
But then
is the
someone-
judge,
Chance to take a look at.
and you are the state. You're not the judge.
Well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentence.
Hey,
Mr.
Robla.
Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it very, of page, during the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk.
And that's what y'all need to stop
That
it
is
at.
equivocal.
That's
To
right.
this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time. And did
That's
not
right.
speak to law enforcement officers anymore. I understand the state's argument about parsing it out,
No.
asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paldo, and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and
That's
to your point
true.
earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just said
That's right.
to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time.
And that is the truth. What the judge is saying. Once a young man said that he do not want to talk anymore. He want to speak to his attorney. He has all his rights. This should stop. This should stop where it is. It wasn't even supposed to go on.
Whether or not it's to this particular crime or any other assertion.
That's right.
That's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated.
What does it?
But the problem is, he invokes, and then we don't
That's
know what
right.
goes on in the 45 minutes, but we come back afterwards, and and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor, that's
They should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about.
And the judge is right. She need to shut up. That wasn't whatever happened in that court at that particular time. Should not even have to go on. Period. Once that young man said what he do, it should have stopped right then. Now, don't y'all just abuse some of the situations that happened in the court then. Jesus, God.
Or the gulping.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the cell. First, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court. But the court.
Well, what did y'all do to make that boy initiate to come back in from a smoke to say what he said? What did y'all do to that young man to make him initiate after he said he wanted to speak to his attorney, take a smoke, and come back in and say what he said? Tell me, what did y'all do? Y'all the minutes boy rights. Y'all didn't do them boy that. Y'all didn't do that boy right. Man, whatever.
Oh, that deference. That is why we have as the burden of proof. Holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his. I'll consider it, but it's this court's opinion that once he invokes,
thank you.
You don't get another bite of the apple by taking him outside, soft.
Thank you.
Giving him a cigarette, some bonbons.
That's what they did.
And then letting him go ahead and then say, "Oh well, let me just clarify with you a little bit." That's not how it's operated. I think that you all are just more so that your detective did something that he probably regrets.
Thank you.
And you all probably would not have told him to do.
Thank you.
This particular investigation or this particular hearing, because what you did is you just now created a wrinkle.
Thank you.
That now I got to deal with, or whether or not the defendant has invoked his right to counsel.
And other than what the judge is trying to tell you, honey, y'all mess up a situation that wasn't supposed to continue after that defendant had amended his rights, young lady. That's what he's saying. Now don't be trying to oh God, Lord have mercy, Jesus Christ. Did you see how they trying to do these young boys? Do y'all understand what they are doing to these young men in front of our face? Oh gosh, here we go. I'm sorry, y'all. I'm sorry.
Yes.
And Your Honor, I'm not annoyed. Your Honor, have with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to.
But that ain't right. What y'all did?
At this time has indicated that it sees, which is that we softened him up with things.
That's my ruling.
Oh God, y'all did this young boy wrong.
Your Honor, we have not presented any evidence regarding what happened in the.
They did that young boy wrong.
State to present evidence of what happened when they went upon the defendant's request to get a cigarette.
Ms. Love, I'm of the opinion it's not going to change my mind at this point in time in terms of because he's invoked anything after that would be improper. It really would be because he's on it. I mean, it'd be one thing if he said, "Well, maybe should I get."
All right, guys.
Man, I'm so sick of the state. It don't make no sense.
And I have to share it.
Same thing Fannie Willis is doing.
Do whatever this, or kind of make vacillate. But he's significant in the sense of I need to talk to my lawyer.
That's right.
To no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court.
Young lady, what made this young man reinitiate without his attorney? What made him do that? What did y'all say to him? and his attorney wasn't there. You can't do a person like that. Boy, they need to stand up and argue with her. She makes me sick.
Has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be.
What made that boy reinitiate something that he said that he wanted to use in court? He wanted an attorney. He wanted to talk to his attorney. Y'all told that boy to go out there and smoke a cigarette, come back in and say what he got to say. You can't do nobody like that if they're not there with their attorney. No, y'all know this boy is young. Y'all can't do that. Come on, state. Y'all crooks. Y'all crooked. You're crooks.
And in this case, the defendant reinitiated the conversation, not the officers.
Y'all good.
We've provided to the court, and we have, of course, we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, that says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard.
Yeah, these
and Your
little
Honor,
boys
given the
wrong.
fact that
I don't
we
care
have
what you say.
a witness here to testify, we don't have to, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked...
Girl, y'all, you listen to what you saying. Listen to what you are saying. Y'all admitted this man right. He said he didn't want to talk unless he had an attorney. Listen to what you saying. Y'all took the advantage of this young man. You took the advantage of the young man into a situation to where y'all made this situation happen with under his circumstances. Man, please. I'm sick of them.
Mr. Weinstein to play for the court the portion to which he objected. That wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. So,
yeah, that's your ruling. Thank you. I have nothing to add, Your Honor.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant,
there she go.
Happened, and we have the.
Do y'all hear what this lady's saying? Do you Pete? Let me calm down. See, I need to be an attorney. You hear what this lady is saying? You see and listen to what this lady is said. They admitted that boy right. He already told y'all he did not want to talk without his attorney. She is skipping what the young man is saying, and she arguing with the judge to try to slide by, forgetting the right that boy had. That young man has a right to say, I don't want to say anything else unless I have my attorney here in front of me.
Here to show it to the court.
Well, based upon what you've argued so far, in this particular circumstance, this court's of the opinion.
She don't listen. No.
It's like this. Once you initiate your right, or your right to be examined and have counsel and to have counsel present at that
Thank
point in
you.
time. The courts are very, let's just say, cautious about reinitiation at that point in time.
Thank you.
And at that, you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop.
Thank you. Y'all understand what the judge said. What the man had said what he wanted to say. Stop it. It's right now. If I was in interrogation and I say I don't want to talk unless I have my attorney in front of me, I want to speak to my attorney. It ends right there. It ends. It's not taking a break, smoke a cigarette, get that young man to come back in here and talk. Now she knows she wrong for that. She knows she wrong. It's bad that we sit here with a RICO only because you got something against Trump. Let me go. Let me let him talk.
Stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor,
And she arguing with you.
Ms. Love. So can we stop at this point in time?
Thank you.
Your Honor,
If you've got if you have other evidence independent of this, I'll consider it at the appropriate time.
and we do, and that is what I was asking. So if the court will permit me to actually,
Do you see what I mean, y'all? You see what she doing? She manipulating what the judge said and what that young man is saying. And see, that's what happened when that young man said that he wanted his attorney. He didn't want to talk to nobody else for attorney. She manipulated the situation to where, hey, let him go smoke a cigarette and let him come back in and talk. You don't do that. It's supposed to end. END.
introduce the evidence that we have as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected.
It's not an interrogation. Y'all, just in case it was an interrogation. I use an example for y'all, okay? Even if I was in an interrogation, y'all supposed to cut it off. I asked for an attorney to be present. Anytime someone asks for an attorney to be present, the conversation ends. That's why where people forgetting where their rights are. Oh boy.
Further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the state, 306 Georgia at 35, Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or the suspect reinitiates the conversation.
But y'all, what made that boy reinitiate the conversation if he said what he didn't want to do? What made that boy, nothing proved right here, what made that boy reinitiate the conversation when, oh God, y'all, hold on for a minute. Let me take a break. Let me take a break. That's what I just told y'all. Hold on for a second. Hold on for a second. That woman on cotton picking upset me. I'm so tired of them running over these young boys. Hold on for a second. Ugh. Come listen to what? Listen to this. Listen to this. Okay. The young man, listen, y'all, listen. And that's why I don't like in the Young Thug case is, excuse me, y'all. One thing that I doesn't like in the Young Thug case, excuse me, is they took advantage of these young boys. This boy asked for an attorney. Once he said he asked for an attorney in the conversation, you're not supposed to question him. But what they did, okay, let's be slick. Hey, y'all, since he don't have no attorney here, let's go ahead and lay him. Hey, won't you take a cigarette smoke? And then you'll be all right. And they know when you take a cigarette smoke, if you're a smoker, what you're going to do is what? Calm down. And let's re-enter or restart the conversation. Y'all manipulate them 16-year-old boys, 18-year-old boys. Y'all did that. That's what the judge got to make sure that everything is straight before he move on state. See, that's what we going through with Fannie Willis. These are girls. These are Fannie Willis girls. Y'all got to listen to what I'm saying.
Honor, at some point,
Your Honor, I'm
Your
sorry,
Honor,
I'm talking,
Your
and
Honor,
I
at
don't know
some
why I
point,
am being interrupted. I will
rulings
not
need to
stop.
be
Your
final.
Honor. I was
She don't listen. She just told.
I'm sorry, I was speaking.
Both y'all keep talking at the same time.
I know, I was speaking, and I expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein.
She talked too much.
You continually engage in this
Thank
pattern
you.
of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just
Got to stop.
I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept
Okay,
that fact.
no,
but
you
Judge, we
don't.
have
No,
not-
you don't.
You
Your Honor,
don't.
we have just not been able
And
to
you
present
still arguing with the judge.
I get it. And if you have an independent basis to introduce statements that may not, are
We discovered you were with more than
I'm
just
so tired of this woman. I wish they'll just move her out the way.
I got a DNA.
She is new at
maybe
this.
not subject to the fruit of the poisonous tree or any other thing or any other issue related to.
Wait, y'all. Let me get right here.
The defendant reinitiates the conversation. The statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation.
What make him reinitiate it?
And Your Honor, we've provided to the
What
court-
make him reinitiate?
We have actual testimony, given that we do have the burden of proof. Your Honor,
Y'all
Munn
full
versus
of
the state
junk.
313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence that's been admitted.
He got it.
The two videotapes are sufficient for the court's analysis at this point in time. So, and
That's your ruling. Thank you. I have nothing to add, Your Honor.
And Your Honor,
See how
happened
she
with
came
the
back
South
in?
Court, the conversation being reinitiated by the defendant.
This lady is a very argumentative woman. She doesn't listen. She don't want to what? Listen. She not understanding because she's not what? Listening. She been doing that ever since she started.
That actually happened, and we have the proof here to show it to the court.
And then you got the proof right there.
You've argued so far, and that in this particular circumstance, this court's of the opinion that
She don't listen. See,
it's like this. Once you initiate your right,
thank
or
you.
you revoke your right to be examined and have counsel, and
Thank
to have counsel present at that point in time. The courts are very, let's just say, cautious about reinitiation at that point in time. And at that, you all presented to me what was the salient point of this particular issue.
Thank you.
So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop.
It's supposed to stop.
And do everything else. It's supposed to stop. I mean,
thank you.
That's this court's opinion, and that's my ruling.
And Your Honor, the thing is,
Here she go.
You're arguing with me now, Ms. Love.
She arguing with the judge.
Your Honor,
If you have other evidence independent of this, I'll consider it at the appropriate time.
Right.
and we do, and that is what I was asking. So if the
No,
court
you
will permit me
wasn't.
to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia.
She just want to talk.
Where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35.
Listen to what you just said, girl. Listen to what you are saying. They don't need to reinitiate nothing when he say he didn't want to talk anymore without an attorney. They don't need to reinitiate. Y'all shouldn't even talk no more. Done. Leave it alone. He asked for an attorney. Jesus.
Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case.
So
It
what?
specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor.
Stop. What made that boy reinitiate a conversation if he asked for an attorney? Y'all manipulated him. That ain't fair. That is not, I don't care what nobody's saying out there. It's not fair what they did to that young boy. That young boy asked for an attorney. Leave it alone. Out, go, let it go. He asked for an attorney until he assigned for one. He still don't have to talk. Don't tell me he has to talk. I'm not on none of them side. I'm just saying he don't have to talk. Y'all don't let that little boy went out there, take a break, go out there and take a smoke, and y'all trying to say, all right, he come back in, you know, a cigarette make him calm down. Hey, let him go smoke a cigarette. He can come. Y'all misabused that. Y'all misabused that.
I'm talking. I don't know why I am being interrupted. I will not stop. I was speaking. I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect to be allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
That's right.
And I know you're being an advocate, but at some point, stop. Just stop.
She got to stop.
I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that
Okay,
fact.
no,
but
you
Judge,
don't.
we have
No,
not-
you
See how she's still talking?
Your Honor, we have just not been able to present the evidence.
No, you. I
that
get
the
it.
state
I
has to
get, and I
present.
get it. And if you,
You can't present the evidence if somebody asks for an attorney. Child, that boy know his rights. You supposed to end the conversation right then. Wait till that boy get his attorney. Good, you are something else.
You have an independent basis to introduce statements that
Thank you.
may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can enter. Of course,
If it's not tied to their statement.
I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here. That we brought the witness here. And had him cancel medical appointments to testify to the court about. We brought the witness here.
I made a ruling. That has nothing to do with it. That's a red herring, and you know.
There you
No,
go.
Your Honor, I was saying that we were ready to present.
Girl, you full of junk. You are full of it. You are full of it. Y'all better check that prosecutor. That's why the only reason why them boys in a RICO in the city of Atlanta do are Fannie Willis and them her people right there who talking. How in the world, number one, it's gonna be a RICO and you ain't collect everybody. You kept the one that Fannie Willis talked about out of it.
Evidence, and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof, and we haven't even been able to present the evidence that we have.
You're not supposed to.
Ease allowed the court to introduce the statements.
Don't do it, Judge. Don't fall in it.
States 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to.
Don't do it, Judge.
Have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does
You
not.
cannot present the evidence if the young man say he didn't want to talk unless he get a leverage lawyer. You can't do that. Good.
Have speculation or conjecture.
She trying to use them men.
When the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered.
What make him reinitiate it?
It says, if this or that, then the.
But what made him initiate it when he asked for an attorney? Y'all better butt in on that woman. That woman running her mouth. Butt in on that woman. That darn lady who typing no, she ain't making no sense. You can't reinitiate somebody if they ask for an attorney. Let me stop. Let me calm down.
Reason. And that case, Paldo, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present, and the court is.
Why should y'all present it?
In the form of testimony. And I understand that Mr. Weinstein.
Why should y'all present it if the boy at that time he wants an attorney? But y'all manipulated that young man because y'all know the age of the young man when this happened. Man, go on somewhere.
Wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily.
She won't let nobody else talk.
He ceased it, but then reinitiated it. is something
She's
that
saying the same
the
thing
court should
over and over.
consider. And Your Honor, I don't like.
She talking over and over.
You know, quite disturbing. But I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom.
Now let him talk.
The court's whole purpose for having these hearings is to determine the truth.
Do y'all hear this girl? That woman ain't doing nothing but talking in circles. To keep this man from talking, to keep this man from saying what he had to say, she's not doing nothing but talking in circles.
To decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective...
Now, she won't let nobody else talk.
A credibility judgment before even hearing what he has to say.
May I please speak?
Thank you.
Please. May I please speak?
Okay.
And Your Honor, I was asking that the court...
Are you finished now?
I was not, Your Honor. I was
Your
not.
Honor,
Hold up. You got 30 more seconds. Wrap it up.
And Your
30
Honor,
something.
I ask again the court for the opportunity.
There she
for the
goes,
state
same old
to be
thing.
able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on partial.
They want them boys.
When the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe, if not today. I don't mind doing it. I said in my email to the court and to counsel.
She's still just talking. She
She
like to hear herself on top. She like to see herself on TV, and she like to hear herself talk.
Matter will be right. But Your Honor, I ask that the court, and for the court to allow us to actually present evidence that we have to present. I speak.
Now sit your butt down.
Your Honor, I apologize to the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer.
That's right.
He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port.
That's right.
Taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order.
Thank you.
This continued going back whenever the state loses in this case has got to stop at some point, Your Honor.
Thank you. And y'all better understand what they saying. Y'all need to understand what they saying. Now, I'm sick and tired of that woman. I'm sick and tired of the state. I am sick and tired of the state. I'm tired of them. I'm tired of the state, what they did to these young men at that. Now they older, now they understand what y'all saying. I'm not on nobody's side, I'm on the right side. Golly, man. Once I say I need an attorney, just give me an attorney. I want to get me up to sign to an attorney. Just give me an attorney. I don't have to talk no more. Okay, then what made that boy re-enter the court and want to interrogation? Because y'all interrogate him. Y'all, man, y'all full of junk.
And had his reasons. Now, in this particular situation, I look at the same factors he looks at, but reasonable people may differ.
And Your Honor, the court is exactly right when the court states that I think when Mr. Kendrick, if you watch that video, Mr. Kendrick is getting more and more wound up.
I noticed that. I noticed
that interrogation, and he's done. He's had it with a lot of them. Now, just because they let him cool off for 45 minutes.
Look at him.
For lunch. That doesn't cure that. That doesn't mean that you come back in and immediately start interrogating him.
Thank you.
About Kendra Morton, which is what they do.
All right. Folks, here's what I'm going to do. I'm going to take, I've got something I have to take up now, unrelated to y'all's matter. Let's just take something. I believe lunch may be here. Is that, all right. I'm going to go ahead and let you all eat lunch as our jurors will be back shortly. So let's go ahead and come back for 1 o'clock, and I'll see if I can make a decision.
If you are like most people that want to sell their house quickly,
gave me a headache. I hate for somebody to just be
all you want
slick
is a
and
cash
think
offer
they
on the
smart.
table, ready to
Think they slick and smart and ain't smart and slick for nothing. Just want to see them young men behind bars for something that y'all don't even supposed to have a RICO on. They already done did half of their time. They already done did this time. God, why are we sitting here with RICO? Sick of them, boy. I'm so sick of this sick. Why are we here? So sick of them. I'm so sick of the state. I'm gonna be honest with y'all. Here we go.
Heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more. And at the second video,
I need to talk to my lawyer. I don't want to talk no more. Where is that boy rights? Where's that boy rights? Where is that young man rights? I'm just asking a question. I just asked a question. Where is the young man I need to talk to? Now here go the second video where they try to manipulate him.
Starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I have presented evidence.
I can take this on argument, and that's what I'm going to do.
And that's what we already seen. Now let's hear what my boy said. Let me see what my boy got to say. Once that boy asks for an attorney, y'all, I don't care what nobody say. Regardless if he has one or not, he asked for one. And that's the end. In the bottom, nothing else supposed to be said. Nothing. Want that boy know he need an attorney. Y'all using it. And then at that time, he wasn't his age now. He was a teenager. Y'all tried to use them young boys, man. Y'all tried to use them young boys at that time. That boy didn't have no attorney at first. Since he ain't had now, he said he want an attorney. Hey, bump, beat, bop. Stop the interrogation. He asked for an attorney. He asked for one. I'm so sick of them. I'm so sick. I'm just sick of folks trying to over on these young boys like that.
Adrian B., give me the other recordings. Give me what you have. He did not respond. I called Mr. Steele. I said, Mr. Steele, how many times did you talk to Adrian B.? He tells me, I'm not going to answer that.
He
what
don't.
you're doing is somehow unethical, and we'll take it up with the court in the morning. I said, okay. So, Your Honor, the problem that I have is, one, Mr. Steele is improperly suggesting to the jury, planting in the jury's mind that this witness made certain statements to the police at the hospital when he did not. Mr. Steele doesn't have any evidence whatsoever, any statement. He doesn't have any recording. He doesn't have anything. He has not asked the witness. He has not done anything to present a statement at the hospital by this witness, and certainly not one to Detective Tracy Lewis. So Mr. Steele tells the court that his good faith basis for asking the questions that he is asking is that he is confronting the witness with the statements that he made during the recording that Mr. Steele provided the state on last Monday. When in fact, the information that he is asking, he is not saying, did you talk to Detective Lewis, or you talked to Detective Lewis, didn't you? Instead, he's saying, why, when you talk to Detective Lewis, did X, Y, and Z occur? And that
I don't want to hear that. I don't want to hear her. Just get on my nerve. Give me a headache.
Basis to ask that question. Mr. Bean told me. But now there's come to light that Mr. Bean he's at Grady. He's in Grady detention.
That's right.
But he hasn't made a statement to anybody else, any law enforcement officer.
Let me take you back, because that's not the way I understand it.
Well, did he interview? Did he have discussions with Detective Faust or Detective Lewis at Grady?
I can't tell you which detective. I can tell you that is what he said, and it's backed up.
By whom?
I'm going to show you, if I may.
Mr. Steele's investigator. Sure, we can hear, but let me hear from Mr. Steele first.
Okay. So what happens here, Your Honor, is the last time we were together on March 4th, 2024, the district attorney stopped the cross-examination, approached the bench, and the following occurred. This is an extra portion. I'll mark it as Mr. Williams, number
B.
Sick of y'all.
Dated today.
And what happened is the state, just like it's doing now, accused me of the following. And this is just the context, and then it will get into exactly what you're asking. It's on page 2, Your Honor. District Attorney Love stated, starting at line 13, that I told the witness what to say, that Mr. Bean was never taken to Grady Hospital. From transcript page 2 to 3, District Attorney Love said, Mr. Bean was never interviewed at Grady Hospital. Transcript page 3, lines 3 through 4, and 8 and 9. Mr. Bean went straight from the scene of his arrest to the Fulton County Jail. Page 3, line 18, when this honorable court asked the question, did he, meaning Mr. Bean, go to Grady? Ms. Love stated, and I quote, no, he, meaning Mr. Bean, did not go to Grady. Mr. Steele told you about whatever he's trying to do. You asked me, did he go to Grady? I said, that's what he's saying, or some hospital, yes. Page 3, line 18. 20 to 22. On page 4 through 5 of the same transcript, I asked.
I have a transcript.
Okay. I asked, in lines, it's transcript 4 through 5, I asked for Mr. Bean's statements to police. And he said, this way I understand it, is Jeffrey Williams was not in the vehicle, or he didn't mention him in the vehicle. He put 3 people in the vehicle, and he lied about who was the driver of the vehicle. And I said, it's Brady evidence, I'm entitled to it. Line, transcript page 5, lines 20. Sorry, line 20 through transcript page 6. District Attorney Love answered your question. Nothing shows that Mr. Bean went to the hospital. District Attorney Love on transcript page 5, line 24 through 25. Mr. Steele is misrepresenting that to the court, meaning that he was taken to the hospital. Transcript line 6, transcript page 6, lines 1 through 5. District Attorney Love states Mr. Bean went straight to jail and that the district attorney has the documentation, the printout. I asked to see it. I was never shown it because I didn't believe it to be true. And I'm going to tell you why I believed it wasn't true. To answer your question fully. Transcript line 7, page 4 through 5. I have no good faith basis to ask this question. Ask this question is my words. Transcript page 7, lines 6 through 9. District Attorney Love said that I have nothing of either Detective Quinn saying on recording, hey, he went to the hospital. District Attorney Love stated to this honorable court, continuing to tell you that I misrepresented intentionally. Page 7, lines 10 through 24, that I assume things, nothing on the tape. Mr. Steele, this is a quote, put that in there, end quote. Mr. Steele knows it did not happen. Mr. Steele is manufacturing evidence. On page 10, you advised us, line 20 through 25, the issue is whether Mr. Bean was taken to the hospital, whether Mr. Bean made a statement at the hospital, and on line, transcript page 11, lines 9 through 10, District Attorney Love, again, Adrian Bean never went to the hospital. So I knew that that was all wrong.
Thank you.
But, you know, when a lawyer says something like that, maybe my information is wrong. I'd like to see the documentation. I don't get anything. So, Your Honor, and it's in evidence. If it's not, I'd like to put it in evidence. The reason I believe that he went to the jail, not straight to the jail as being purported, told to you, is that in discovery, the following occurs.
If you move that camera,
I'll mark this as Mr. Williams exhibit number 202 with the court's permission. It can be played for the court. This is the file. It was given in discovery by the state of Georgia to Mr. Williams and all. This is the police radio traffic. You heard some of it during the trial through the witness who identified the radio traffic. It starts at 0054. This is Z radio, 1231 hours through 1300 hours, so 1231 through 1 o'clock. And it reads down here on Cleveland Avenue, status of 4, that means the ambulance, that through the testimony. For a 34-year-old black male with injury to his shoulders, head, and to his back. If you remember, Mr. Bean was born 6/22/1979. That would make him 34 years old on September 11, 2013. It says, okay, Cleveland Avenue, Old Hayfield, 122, Cleveland. Next ends at 112. At 1300, Major, where do you want me to bring the bus? Meaning the ambulance. Oh, come up here to Cleveland and Old Hayfield. Take a right. I'm standing here. I'll direct you in. That's at 1314. At 1602, 2308, I'm still at Cleveland Avenue, Old Hayfield. I got a perp in the backseat of my car. That's at 1607 it ends. At 2808, 2308, I'm right in the parking lot. Tell him to come down Cleveland Avenue. I'll get him. I'm in the parking lot of the Coin Laundry. All right. Trying to get Grady to find you. Right. Then it says unintelligible for my notes. I'll get out of the car and flag him down. That's at 2028. Then at Mr. Williams, I'll mark it exhibit number 203, Your Honor, for purposes of this, so I'll play it for the jury. File Z radio, it's 1301 hours through 1330. So that's 1:01 in the afternoon to 1:30 in the afternoon. Same date, September 11, 2013, 1842 on the recording. 13 radio, following Grady Unit 320 down to Grady Hospital, 1848. At 2736, are you en route with another victim? We en route with another suspect. The other suspect, okay, I copy that. He's 1050. Also at 1050 is a shot. Says, I don't think so. He's going to be in custody. He's in 83. 83 means another warrant. Mr. Bean at that time had a warrant for the year before for shooting 2 people. You heard that impeachment. He pled guilty to that. He received before the Honorable Judge Downs 15 to do the
Told you they already done did this time.
Okay, so why not bring him to Grady? Excuse me. So why not, bring him to Grady? Isn't he injured from the crash? He's probably going to be injured, Sarge. That's why they're taking him to Grady detention. So probably be injured. Okay, copy that. He was the guy that was hit by the car, question mark. I don't know which one the guy he is. This is the one that AC, meaning you heard from AC Booker Higgins, officer, and them got over at the Barber Institute. That is Mr. Bean, in fact. Yeah, that's affirmed at 2836. Then I'll mark it Mr. Williams, Exhibit 204. It's file Z radio. It's 1331 through 1400 hours, so it's now 1:30 to 2 o'clock. 2820, raise 2013 and have them go over. We got the 83, that's Mr. Bean, down here at Grady, and that's at 2827. So I knew he was at Grady when Miss Love was making these representations that I'm misrepresenting. But, you know, I don't find lawyers to do that. Then, Your Honor,
So they lied.
Recording. And it's at 1949, we can play it for you. It's Detective Quinn and Mr. Bean. So it's 6 days later. So it's now the 17th of September, 2013. And Mr. Bean is being recorded the whole time by Detective Quinn. And Detective Quinn states as follows.
They don't have nothing to say when you up there.
Excuse me 1 second, Your Honor.
Don't make no sense, man. They ain't got nothing to say when he up there. But let somebody else go up there. Take advantage of what we done said. Ain't nobody saying that. They quiet when still get up there. So did the boy go to the hospital or did he go to jail? They don't mess with Mr. Steele.
At 4456, actually. In what, sir? This is September 17, 2013, recorded interrogation. Detective David Quinn, now retired, with Mr. Bean. And I'll play it for you if you'd like, but Adrian Bean states as follows. Yes, sir. I lied to the detectives when they first came and talked to me. And I told them that's probably the lies that you're talking about. Detective Quinn then said, okay, what did you tell them? Adrian Bean, I told them Big Fred was driving. So we're sitting here. I have zero information on when Mr. Bean spoke with detectives. But I do know this. Mr. Bean told me that he spoke to detectives at the hospital. Detective Calhoun testified before the court. Went down to the hospital, spoke with it.
See, the boy was at the hospital. He was at the hospital.
So I'm recording Fred Prethrow. Fred Prethrow was asked, what happened? Who was in the car? Fred Prethrow said, DK, Adrian Bean, and me. 3 occupants. And so I'm recording. Detective Lewis goes and speaks with DK, who is known as Mr. Walter Murphy. I have no recording. I have no recording of whom? Detective Lewis at the hospital, Grady Hospital, September 11, 2013, meets with Walter Murphy. And Your Honor, as my eyes roll out of my head, I'm about to show you why I do not believe the City of Atlanta Police Department at all. This is served in discovery. I will mark it, Mr. Williams, C and D. And then you tell me if I'm supposed to believe the allegations from the state of Georgia.
And Your Honor, while Mr. Steele is pulling that up, I am reiterating that
Why he pulling it up?
do not believe is not a good faith basis for asserting facts that are not in evidence.
So let him finish and I can kind of have another conversation with y'all about it, okay?
I'm almost still.
May I approach you?
You may, sir.
Now, for purposes of motion, I'm handing the court what I was provided in discovery by the state of Georgia. I made it for today's date, Mr. Williams. Exhibit C is in Colette or Charlie, and D as in Delta. And if you will see and take note, on the top, it's the City of Atlanta Department Supplemental Incident Report, narrative only, page 1 of 1 on both C and D. Your Honor, the incident report is exactly the same, 13-254-1308. The complaint name in both are left out. The date of the report is the same, 9/17/13. It says reserved, and nothing's in there. It then has a narrative section with an affidavit. Your Honor, the first paragraph has Detective Lewis going to, the two people going to the hospital with injuries. Investigator Calhoun and myself, Investigator Lewis, went to Grady Hospital. If you remember from the testimony, Investigator Calhoun goes and meets with Mr. Plethora, 3 people in the car. Investigator Lewis goes and meets with Mr. Murphy. Investigator Calhoun recorded it. I have this report on Investigator Lewis. Next paragraph of C and D are identical, Your Honor. Once we arrived at Grady Memorial Hospital, there were 2 males being brought in for gunshot wounds. I was advised by Grady medical personnel they're not life-threatening. We could speak with them once they got stabilized. It's going to be identical. The next paragraph, Your Honor, the first 2 lines. The first line, I spoke with Walter Murphy in C, gives a date of birth, 8/9/91. He had sustained a gunshot wound to the left thigh. It's going to be identical. Then it starts, he advised that. In C is in Colette and Charlie, but in D, it says, he advised me during D. Then D is whited out. The entire part is now vacant. C goes on to say that The other three males, now there's three people in the car, one named Bean, drove to the laundromat on Cleveland Avenue to meet up with another male to sell an ounce of marijuana for $50, and it goes on. Your Honor, at the bottom of C, it is signed, same looking signature of Investigator Lewis, I presume, on 7, reporting officer's signature. It is also signed similar on D, Mr. Williams D. The APD number is written in on D, but it's typed in on C, and it's the same ID number, 3081. As far as section 9, which is in the center on the bottom, it says sworn to and subscribed before me the 17th day of September 2013 in type on C. D, it's in writing. And then on the bottom, it says supervisor's signature, and a supervisor actually signed off on C, which is supposedly a complete report, as also D, which is clearly whited out. In addition to that, Your Honor, on both C and D, there is a statement at the very bottom before the signature, above the signature line, the undersigned being duly sworn upon his or her oath deposes and states that the foregoing is true and legible to the best of his or her knowledge and belief. So when I sit here and I hear Miss Love tell me how diabolical I am and how I don't have a recording, or I don't have a statement, or I don't have a note or a summary.
She don't want to hear what you got to say.
Mr. Bean was interviewed at the jail, at the detention center, after Miss Love told this honorable court total misrepresentations. I don't know. I assume that she had a good faith belief, because that's just what I do with lawyers. But she attacks me like I'm out of my mind when this is in the discovery. This is all, she knows this. And then I'm giving C and D, which is clearly going to come out before your court, because if the state doesn't call the investigator Lewis, I'm calling Investigator Lewis. Because this is what I would say is corruption.
Thank you.
Because I don't see this often.
Do we know why
Right.
why one statement is incomplete and the other one is?
And why I have no recording. And why I only have this on the 17th day of September. And why Detective Calhoun's is all in a report on that day. And why is it that Adrian Bean tells Detective Quinn, when I first spoke to the detectives, I lied to them about Fred Prethro driving? And why is Adrian Bean telling me, yeah, the police wanted young thug, Jeffrey Williams, whatever the words are, involved in this case?
They want thug.
Is it that Adrian Bean is on a jail call with his wife? It's the next day. It's September 12th of 2013. And his wife says on that jail call, the homicide investigator, who's going to be Detective Quinn, came by a second time yesterday. That's the date of the incident. And he told me that the driver, people think the driver's a woman wearing a wig, but it's really a man. It's a boy. And Detective Quinn is giving this information. And whoever the driver is in big trouble, but if Mr. Bean is a passenger, he may not have any charges. And on that same recording, Adrian Bean is telling his wife, they gave us a story to tell. And Adrian Bean tells me, with Investigator Martin, that story to tell happened at the hospital. Now, he blames it on Detective Quinn. It's also 10 years before, so maybe it's not Detective Quinn. I'm not saying it's Detective Lewis. My questions were some detective. But his point is, it's a detective that introduced Jeffrey Williams to this.
Right.
And then you could go
And
to the
they
crime,
lying.
which I'm going to do, crime scene photographs. There's not room for 4 people in the back of the car. In addition, there's no shooting in that car.
Let me tell y'all something. This whole case is to drag something on a person that hasn't done nothing. And that's Young Thug. They want to make him be the suspect, and he ain't around, so they making it look like he called in the shot. Y'all gotta pay attention. Y'all gotta pay attention. Listen what he's saying. Listen what he's saying, not what I've said.
Police did it and they cleared, and I'm not saying Robert Sinell was not justified. I am not saying that. But Robert Sinell discharges firearm multiple times, and it crashes through the very rear window on the passenger side of that 2004 Nissan. Those bullets go somewhere.
That's right.
Mr. Murphy is shot twice, one in the lower ankle in his right leg and one in his left leg up
That's
the thigh,
right.
which strikes an artery. That's why there's so much blood from him. Fred Plethro is shot through the headrest. Now just imagine a 6'3" young man sitting in the ways of those bullets. They can't get around him. There is no one else in the car. And the state is blaming me for this? This is outrageous. And I can ask every single question the way I ask it. I ask it properly. And Adrian Bean, for all that he's worth, the jury makes a determination. And what Miss Love is trying to do is obstruct the truth from coming out, because she knows all this.
That's
why
right.
Last time I was a fibber for telling the court that he went to Grady Hospital.
That's right.
When she realizes it's patently true, now I'm a fibber because no one spoke with him, and I'm just supposed to believe that these officers took him down and they had him on wraps and no one spoke with Adrian Bean. I apologize to the court. That's also a jury. Juries make those determinations. In addition to that, this case should be dismissed.
I said that in the beginning. Why are we here with a RICO? Why are we here? Why are we here and these boys already done did their time, y'all? Why are we here with this case? The one y'all want who to be involved in something y'all ain't got nothing on him. Oh, wait, Jesus. Oh, I don't understand.
I'm going to do that once I get it into evidence before the court, but I'll do it now since it came up and Miss Love is attacking me. And this evidence is wrong. Also, ask continuously for all these videos. I don't get it. And then months later, I'm getting a video on the shooting at the movie theater, which I know you don't know about yet, but it's about Christmas of 2000, maybe 15. The point I'm trying to make to you, Your Honor, is this is a moving target by the state of Georgia. And no, to say that I have no good faith belief because I can't show this honorable court where these statements are, that's my point. It's Brady evidence. This is all Brady evidence. And if this happened in another forum, the state bar, I'm not doing that. I don't report people. I believe in people and lawyers. I don't know what Miss Love is doing, but to attack me on misrepresenting to this honorable court, I have never done that. I will not do that. And I will never, ever do it to any court. That's not what we do.
That's right.
But I also understand my duty is to make this process rigorous, zealous, and I am going to fight for Jeffrey Williams in every lawful and ethical manner the entire time. And that includes destroying Adrian Bean's testimony and revealing the truth. In addition to that, Your Honor, the state of Georgia calls our investigator and wants to know dates and how many times we supposedly met with Adrian Bean. That is work product. That is not a statement. That is not covered in any type of work product, and this is not my witness. So when you ask the court and you never got the answer, but OCGA section 17-6-4B as in Barry, Bravo. May I approach, Your Honor? You may, sir. right, this is 17, I've handed this honorable court, the Honorable Mr. Kearns and prosecution of the Honorable Madam President, District Attorney. 1716-4B1, it's on page 3 of 5 of the copy I've given the parties. It states the reciprocal discovery, which Mr. Williams did opt into. B1 towards the center but top of the page, it states the defendant, within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the honorable court to inspect and copy or photograph books, papers, documents, photographs, tangible objects, audio and videotapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings and places which are within the possession, custody, or control of the defendant, and this is what I stress, and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at trial. I am not in my case in chief. This is the state's case in chief. I'm on cross-examination. On 17-16-7, which is the other copy I've given this honorable court, and the parties, our legislature wrote, no later than 10 days prior to trial or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in the possession, custody, or control of the state or prosecution, or in the possession, custody, or control of the defendant or the defendant's counsel that relates to the subject matter concerning the testimony of the witness that the party in possession, custody, or control, this is what I stress, Your Honor, of the statement intends to call as a witness at trial or at such post-indictment pretrial evidentiary hearing. I am not the person who intended to call as a witness at trial or any such post-indictment pretrial evidentiary hearing, Mr. Bean. The state called him. I don't have to, by law, give anything to the state.
That's
that
right.
I did. And calling a person under the umbrella of the attorney-client privilege and asking to give over information is unethical. When Ms. Love asked me yesterday, I was very polite to her, but I told her I feel like I would be.
I mean, yeah, you're right. You're entitled to them, but it's for his case in chief.
Your Honor, the 1716-7 specifically says any statements of a witness that the defendant intends to call as a witness at trial. And the defendant listed on his list of witnesses that he intends to call.
Okay, but it's not his case yet.
I understand.
And he's no burden to do that. And he may change his mind in that respect.
Thank
so
you.
I'm not even going to consider that until such time as the defendant makes his case in chief. But I agree with you, and I agree with Mr. Steele. It would need to be turned over at that point in time.
Your Honor, additionally, Mr. Steele failed to say to the court, point to the court. Instead, he spit out allegations and insults that were meant to, I suppose, take the place of actual evidence. There is no statement, Your Honor. He pointed to, there's no statement made by Adrian Bean at the hospital. I was wondering why he didn't play the interview that he had with Adrian Bean. So at this time, Your Honor, the state tenders for the court's consideration the 10-minute interview that Mr. Steele has.
Can I hijack off for just a second? Folks, it's about 3:40, and can we, since I don't think we're going to get to our jury today, can I ask them to come back tomorrow?
The state has no objection.
Mr. Steele, anybody? Because it sounds like we haven't done anything. We're not going to. This is going to consume the rest and the residual of the afternoon in Wheeler Parliament's terms. All right. Sergeant, if you could just release our jurors and tell them that we will see them tomorrow. Hold up. Let me give you time. I'll do it. Just a second.
But this ain't nothing but old crooked Rico. And they can't even put Young Thug nowhere. They can't put him nowhere.
All right, ladies and gentlemen, please be seated. All right, ladies and gentlemen of the jury, good afternoon. Okay, I got good news and I got, not so good news, all right? Which one do you want to hear first? Okay, we're not, okay, I like you all. All right. We unfortunately got bogged down with some business that we need to take up outside your presence and hearing, and of course I told you that happens.
Okay, right here in this thing, they are dismissing uh, uh, the jury. So right here in this thing, right in the jury, not in this, okay, at all. So I guess right now Miss Love's supposed to be showing the interview. Adrian, I think Adrian. How y'all doing today? Excuse me. Okay, y'all listen to this. I have to play this.
RIANDEAN. And can we just have your phone number for this recording? 443800730. The date of birth, please. 06221979. Mr. Bean, do we have permission to record this? 40 years old. Do we have permission to record the conversation? Sir. Okay. As you know, as I just said, I represent Mr. Williams, Mr. Jeffrey Williams on trial right now. Young Thug is performing name. Jim Martin Jr. and I work together. Jim Martin Jr. is an investigator, a licensed investigator. And I just want to go over what you told us previously and make sure this is accurate. If it's not accurate, all I want, like I told you before, is the truth. That's all I want. You were in I'm not saying you were every day, but you were in a situation involving a good friend of yours, a very close person to you, named Dirty Red, with Mr. Walter Murphy and Mr. Fred Prethro, and Walter Murphy is also known as DK. I mean, it's what you told me. Is that correct? Correct. And I'm telling you the date. I'm not saying you remember, but we're talking about this the 11th day of September 2013. So September 11th, everyone knows, Mr. 2013. And there's a shooting and a car that creams into a side of a laundromat. You know what I'm talking about? Not familiar with. Okay. Now, you were never charged with that, or you were never prosecuted for that case. Is that true? Yes, sir. We didn't ever even go through the motions on that. So, and what happened with your charge? The case was dismissed. Okay. That's what makes sure. The whole case totally dismissed. Okay.
Y'all hear that? The case was dismissed. A lot of this stuff that we are looking at right now in court has been dismissed, already been charged, and they already did the time for us. So why are we here with RICO? Jesus.
Now, I'm interested in Jeffrey Williams. Was he in, around, a participant, giving direction, anything involved in that event that we're talking about involving Dirty Red September 11, 2013. No, sir. Okay. Like I explained, when, all that occurred, everything took place, they was, trying to force him in on that he wasn't even in. Like I said, I'm not going to lie on the brother. You know what I mean? And, he wasn't with us, Young Thug, but not in the car with us. I don't even know how his name really got mentioned. Maybe it was a lot of hype through the streets. Or, I might have was in confidence talking and said his name, but I ain't, him and Linda saying that he was with us. You know what I'm saying?
And when you say that they wanted him involved in the case or whatever your words were, who was
detectives and other, people that was inquiring, you know what I'm saying? I don't know, discuss the neighborhood or whatever.
the police?
Yeah, police.
The authorities or whatever, the prosecutors, the police?
Yes, sir.
Okay. And I played for you a recording a short while ago, and this too. I promise you I'll email it to you, the second one, and I will. But the one I played for you has you and your wife speaking, and at some point around the 11-minute mark, you said they gave us a story to tell. Remember hearing that?
Yes, sir.
And can you tell us what that meant?
That they was really telling us to, like, hey, put Doug in on this right here. You know what I mean? He don't put him on that. He could be facing a lot of time and all type of shit like that. You know what I mean?
And who is they again? I know.
At the point.
Okay. And the other prosecutors and police?
It was just really just him. And, it was just really him I had mainly dealt with.
Okay.
There was a few more officers that was just around, you know what I'm saying? But we was in the hospital. I was in the hospital, you know what I mean, when shit happened. So it's like they pushed in and I was out there. I don't know what's going on. So, yeah, as far as cases.
See, that boy just said he was in the hospital. And before I let y'all listen to the recording, that she said he wasn't in the hospital. Why they trying to catch them boys?
Accident. Right.
The car, they say.
We crashed.
Yeah, careened over a police car and into the side of the building.
Right.
You were driving the car.
I was the driver.
Okay.
And he trying to say he was driving.
Yeah.
You know what I mean? So
the police wanted you to say
you got to get up. That's what he done. So was not in the vehicle with us.
The police want to say Young Thug was the driver, and he wasn't in the car. Young Thug wasn't in that car, y'all. Boy, they don't like that boy. They don't like that boy.
Can't no man, I'm 42 years old, can't no other man tell me what to do. Can't no other man make no other man tell no other man what they need. Everybody wrong.
So why did you tell the police, because I'm reporting that Jeffrey Williams was involved in this armed robbery because the police told you to say that so you get out of trouble? Is that the reason?
Yeah.
Okay. Now you're also on another show called
So the police told that boy to say that Thug was in that car. And that's why they planted in that girl head that stayed in that apartment that, Young Thug ran up in that girl house. Man, they were true.
Yeah, that's the one I want to hear.
I'm going to send it to you. But for what you say, the reason you would have a jail call with your wife and a friend of yours or whoever, you're going to tell us. That's because the same reason. It's just the police gave you something, a story to tell you. It's going to say it to everybody. Okay. All right. We're going to shut the recording. It's what you told us the truth because that's all I've ever asked you for.
That's it?
All right. Did anyone promise you anything, threaten you?
Nobody probably going for that.
And Jimmy and I have been stored. Investigator Martin and I participated with you all the way. Is that true?
Right.
And Investigator Charles Bill
I've been working hard trying to catch up with I just stopped working 2 jobs, so I'm a world worker day and night. So appreciate certified flag.
And y'all know who that boy is. Can I tell y'all who that boy is? That's the boy who lied on the stand. That's the boy who a bald head, who said that he came up there with that jacket on, that motorcycle jacket on. Ain't that something? Damn on that recording. Wow. What is this? Y'all just don't know the state. Y'all just had to defend it.
Certified supervisor.
With this recording.
I was doing dishwashing.
she said it's going to come up. You did go to prison for 3 years, got 10 to do 3. Right. But I know what you explained, but just explain again what truly happened. I know you took a break.
I don't even know. When we went in the court, me, Ross Murphy, and I think one day we come to court and they said, case dismissed, said the victim had killed himself or something like that. So I'm like you don't got a victim.
I'm talking about your other case. The one you went to, yeah.
But that had something with my children. That ain't got nothing.
But your children were no.
I got a question to ask y'all. The boy who took the stand, why did they play this recording? Why he said he couldn't remember? I don't remember. I don't recall. Why they didn't play this?
Well, my kids, I had a Polaroid. You had a 10-year-old and a 12-year-old that was choked. And one of them punched in the stomach. This was my kids. And I went around there and held with the guy in the car by myself. And I got caught up in it, and I explained to the judge what happened, and the judge sentenced me to 10.
And you caught up with the person that you killed.
Yeah, I shot both of the guys, in the midst of
And how old
on them. The one was 28, and the other one was 31. They was jumping on a 10 and 12-year-old about that basketball goal in the neighborhood, which was my kids. Right. So, everything that went on me, they happened with me and my kids. You know what I'm saying? It had nothing to do with none of that.
And then, last thing, and I'm sorry that you went through that and your children. YSL, are you ever part, they're saying YSL's a criminal street gang. Are you ever part of a criminal street gang, YSL?
No, sir.
Do you know Jeffrey Williams to ever commit a crime? Ever?
No, sir.
You only know him through his music and his reputation.
The only time I ever heard of him, on the radio. Through our neighborhood,
This the boy who got on the stand and lied on Young Thug. This the guy who got on stand and lied on Young Thug. Who said, I don't recall. I don't remember. What was his favorite word? I don't forgot his favorite word. But that was him.
I'm saying I don't got no issue with him. I don't hang with him. We live in two different separate places.
Okay, and whatever happened, and I understand it was dismissed, but on September 11, 2013, as far as you're concerned, that had nothing to do with criminal street gang activity. Why, sir? Okay.
No, sir. I ain't initiated in that. I mean, like I said, I don't got no tattoos, no name, no sign. Nothing on my body that will make me, nothing around me, period. So it's okay. I'm a working man now. Is it okay if I turn the tape off? Unless Brian has another question.
I just gotta announce the time.
Okay, it is now 11:20 a.m.
And we're gonna, where the Kroger's will, is it your neighborhood? The Kroger in your neighborhood? Near,
January 22nd, 2023.
Listen,
Young Thug on Tower. Young Thug was not in any vehicle with me. Never gave me no permission to do no crime. I'm way over than Young Thug. He never directed you to commit any criminal activity whatsoever.
you know him as a good person?
I ain't never heard God do nothing crazy.
Let me tell y'all something. Every police in Atlanta know who Young Thug is. Them police, them two cops know Young Thug when they see him. Come on, y'all. Jesus.
He take care of the neighborhood, he take care of his family. You know what I mean? The street, everybody want to be against the man. You know what I'm saying? So you know how it goes. When you in the streets, you making money, rich, you do anything with music. You got the gun stuff. You take their name and put it on what you got going on and just be, have a lot of rappers. You know what I'm saying? They make it be a game, but it's not a game. I'm over here doing good delivery stuff. You don't see me in the neighborhood, bumming around in the neighborhood. I'm in the studio. Right. Man, making music. You know what I'm saying? Like I said, that was like 10 years ago. When they talk about me and this guy just killed himself. That should be over with, man. You know what I mean? People kill this
Not over with, but we appreciate it. All right, thank you. We're going to shut the recording off.
It is now.
And ain't nothing they could do with this, y'all, because the boy said Young Thug wasn't in the car.
I say, it is 11, keeps going off the time. Let me 11:22. Cut it off.
And he's sitting over there shaking his head.
So, Your Honor, that is the entirety of the conversation that has been provided to us. The court heard the interaction between the defendant, Brian Steele, and Mr. Bean. Mr. Bean, when asked, I guess I know based on the conversation we heard that there was some conversation that he and Mr. Steele had outside of this. Of course, on redirect, we can ask that question. What was told? What were you told to say? Was there anything you were told to say? But I think it's important. At one point during his cross-examination, do you remember them explaining that they, meaning the detectives, tried to force Jeffrey Williams or Young Thug into it? Do you remember saying that? Mr. Bean said, I think that was something you said, right? So all throughout this 10-minute recording, we hear Mr. Steele leading Mr. Bean, putting words out there, Mr. Bean acquiescing to what is being said.
Oh, Lord, have mercy.
The only thing regarding a statement that Mr. Bean tells Brian Steele, true or false, the only thing he says about a statement that he gave anybody was that they trying to put Thug in here. And if you don't do this, you're going to be facing a lot of time and all that shit. And Brian Steele said, who is they again? And Mr. Bean said, Detective Quinn. And then Brian Steele said, no other prosecutors or police? And Adrian Bean repeats, no, it was just Detective Quinn. In the interview with Detective Quinn starts that recording before he ever even approaches Adrian Bean. And that happens on September 17th, 2013. That's 4 days after the incident occurred, long after Mr. Bean had been released from the hospital. And he was released from Grady detention around 6:30 and was not put in the jail at 12 o'clock midnight on September the 12th. The first thing you hear Detective Quinn saying is something akin to, I'm Detective Quinn, have we met? And Adrian Bean never says, yeah, remember I talked to you yesterday or day before, some other time. And Adrian Bean, in his conversation with Detective Quinn back in 2013, he says, yeah, I told them at first. And the reference that he is making based on everything that is around this conversation is that while he was on the scene, he told them someone else was driving. Mr. Steele's question to Adrian Bean, why did you tell the detective at the hospital, Grady Hospital, on September 11, 2013, that it was not you, but your dear friend driving that Nissan vehicle? That's so wrong on so many levels. Number one, he is injecting stuff, assertions to the jury that doesn't exist, manufacturing evidence. What he should have done was ask Mr. Bean whether or not he spoke with someone at the hospital. He can lead him. He can say, you spoke with the detective at the hospital, right? Because that's all that's in this interview that we have.
Well, you can't tell nobody what to say.
You spoke with the detective at the hospital, right? And that detective was Detective Quinn, right? Well, if he says, I don't know, I don't remember, then he can confront him with.
But he ain't have to say that, though.
Which is, didn't you tell me and Investigator Martin that
you can't tell them what to say?
He can say yes or he can say no. And then he can play the statement that he talked to Detective Quinn at the hospital. What he cannot do is assert as if it is fact, why did you tell the detective at the hospital, Grady Hospital, on September 11, 2013, that it was not you, but your dear friend driving that Nissan vehicle? He never says that. Mr. Bean never says that in this interview with him. So Mr. Steele is sitting here conveying to the court as if he doesn't realize that he is impermissibly injecting facts that are not in evidence before this jury. Like, what, Judge? Mr. Steele's been doing this 3 times as long as a lot of us in this courtroom. He knows what he is doing, and it is disingenuous for him to suggest that he is innocently, impermissibly putting facts in front of the jury that don't exist. He says, when I object about that and say there are no facts and evidence, there will be no statement put into evidence, so I object. The court asked Mr. Steele, did he make that statement? Mr. Steele refers to the court. He says, yes. And then the court asked to see it. Mr. Steele says, yes, sir. And didn't produce it. Even today, he hasn't given anything to the court that shows where Adrian Bean said any of these things that he's asserting that he said in his questions to him.
But still, y'all already put Adrian on the stand.
I think he's given me these statements in terms of Williams, Charlie and Delta. And I also want to say that he also.
And Your Honor,
Don't cut the judge off. Just to say what you got to say.
And traffic, it was played from, or at least proffered from my consideration, Williams 202 and 203. And the recorded interview of Bean and Detective Quinn. So, I mean, I think he's got some basis to ask some of these questions. Now, I would agree with you that maybe some of the questions are objectionable in terms of their form and or substance. But
Judge, the defendants exhibit 1 and 2.
She just ignored
whatever
him.
he called them.
See,
Tracy Lewis's report. Literally, Your Honor, the court has Delta being the draft, the partial draft. He has sat here and literally asserted that something is whited out. If you compare
we don't know what happened.
So
Your Honor, the point is that Mr. Steele is trying to use that as a basis for impermissibly.
Well, he can do whatever he want to do.
This jury, speculation, conjecture, and assertions as facts in his questions to Mr. Bean. If you compare the two, it is literally the first draft of the final draft. You have Tracy Lewis writing this entire statement, which is defendant Charlie. And you can see the paragraphs are literally the same. She started it on this, and just because we gave them everything is no, I mean, just he's going to exploit it, I guess, to his game, whatever way he can do it. But Judge, it's literally
Can't say that.
Charlie is the complete report. Delta is the partial report. And the only person that Tracy Lewis speaks to in this report, and in Detective Quinn's report, he references that Tracy Lewis spoke with Walter Murphy, and she made a report of her conversation. And in his report, Detective Quinn also knows that Detective Calhoun spoke with Frederick Prothro, and he made an audio recording of his conversation.
Okay, but let's focus on what Mr. Steele has a belief of. Okay, I think that he has more than kind of.
That's right.
Why it is he asks these questions. Now, I think that part of your objections are valid, but I think that he is more than proffered as an advocate before this court that he had a good faith basis to ask some of this. Now, you have a disagreement as to why and how, but.
And Judge, that is the only disagreement that I have. I don't care if he says, did you talk to a detective at the hospital? That's the point I'm making. I don't care if he says, did you lie? I don't care if he says, did you talk to your wife on an unrecorded line? I don't care if he does that. But what he does is says, why did you tell your wife on an unrecorded line at the hospital? So that necessarily assumes a fact that is not in evidence. He's sitting here telling you, I don't know, maybe there's a statement, I don't know, the court hasn't given it to him.
Now that I've heard a little more, I think that would be.
That's right.
I would probably sustain that objection. It probably needs to be clarified.
He did it throughout, Your Honor. He did it. There's a total of 28 times where he does something like that. Literally, he says, do you remember explaining that what you were referring to is at the hospital, that the police were telling us to lie, put thug in it. When you talk to Detective Lewis.
Okay, but that's.
Listen.
So when he says,
see, she don't listen.
That there's no evidence.
See, let me tell you something. Let me tell you what her problem is. She cutting the judge out and she not listening. I never seen nothing like this in court. This is the boss man in here. And he not even finished saying what he got to say for you to rudely interrupt him.
Is asserting that
don't mean you right.
And then asking the witness improperly in front of the jury.
Did he ever talk to Detective Lewis?
No.
How you know?
I'm telling you, Your Honor. And then Mr. Steele gets here and says to you all this stuff and still never shows you anything to suggest that Adrian Bean talked to Detective Lewis.
Okay. Mr. Steele, you want to respond to that? Because that's critical to me. I mean, it's critical in the sense that if there was no conversation between the two of them, then that would assume facts, not evidence. Hold on, I'm asking Mr. Steele a question.
She's talking too much.
Hold on, Miss Love. Okay.
She don't want to listen. Look.
On the recording that you just heard at the beginning, the first couple of minutes, I don't have the time in front of me, was not shown on the screen. When he spoke with the detectives or authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to the detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is that he did talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not. It would be a violation before me for you to put that in front of this jury.
You're not going to do it. In the September 17, 2000.
You were saying to the court that you have a belief that there is another statement out there. There's not.
How did you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor, listen.
Go ahead and make the statement in contravention to what I've just told you, and I'm telling you that you will have some problems in front of me.
Woo!
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. It's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question.
Your Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who he's talking about, the car.
But we still don't know whether or not he had a conversation with Detective Lewis.
And I made it clear, it's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, or any other detective or law enforcement, read the transcript. I made it clear. I don't know. He doesn't remember names. He says it was Detective Quinn. Also on the recording, on Sunday, January 22, 2023, Mr. Bean is the one who said this happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement made.
We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. I have a lot of different remedies I can execute at that point in time.
There has to be, that's why I gave you
But you can't intimate or otherwise cross over the line when you don't have the statement to back it up.
Judge, I've been robbed of the statement.
But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up and says, hey, happen to have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again.
I'm saying it's been deleted. It's been destroyed.
We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't.
Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car? He gets cut off. Detective.
Listen to what Adrian lied on the stand. Adrian lied on the stand, y'all. He lied. Lying self. Talking about he don't know. I don't remember. I don't recall.
Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
But that doesn't still give you the latitude at this point in time to ask that question. Now I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking when you have to find the statement for. I'm telling you, the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry. No, it does not.
Mr. Steele, you got to have it. Evidence, possible cause, shown, heard. Do what you're supposed to do.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me.
I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to the district attorney love. I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me on recording that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over.
Then we'll have some problems. Then we'll have some issues.
I have some issues now. I've been begging for it. The state's supposed to give this.
Hold on, Mr. Okay, stop.
State do supposed to give it to him.
Ms. Love, have you inquired of Detective Quinn other statement, or maybe?
Judge, that's just it. Mr. Steele is literally manufacturing evidence. There is no other statement. I have asked whether or not there was a statement. I asked Tracy Lewis at the hospital. Let me be real clear, because he keeps conflating stuff. Adrian Bean never told Detective Quinn that he made a statement at the hospital. I have his transcript.
Okay, but we don't know where he made the statement, and also he's lied, so we don't know what.
Thank you. He lied.
Your Honor, to be very clear, there is no statement. I have asked Detective Lewis. They can ask Detective Lewis. She never talked to him. Detective Quinn, who is the only person, it's not just police, the only person Adrian Bean asserts to Brian Steele in this recording that he gave us, this 10-minute recording, he said, I spoke to Detective Quinn. It's obvious that he didn't speak to Detective Quinn at the hospital because the first time he met Detective Quinn was September 17th when he pulls him in for the interview. Literally, Mr. Steele is manufacturing something. So when the court is even asking me, okay, do you know where this statement is? Assuming that there's not a statement. There is no statement. There's no evidence. That's the problem with Mr. Steele asking questions the way that he asked them. He is assuming facts that are not in evidence. And he is usurping the jury's province and their ability to discern and weigh evidence because he is injecting assertions into his questions about things that don't exist. Similarly, he says, do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013? That's what he asked the witness. You heard the interview. He doesn't say that anywhere in that interview. This is the kind of manufactured evidence Mr. Steele keeps putting in front of the jury. He never said that during the interview, yet that's the question. That's the question Mr. Steele asked Adrian Bean on the stand. Nothing like that ever happened. And his conversation, during his cross-examination of Adrian Bean, the cross-examination is replete with examples just like that. There is no statement. He can't sit there and say there has to be a statement and then ask the question as if there is one, because that's improperly asserting to the jury something that isn't factual. There's no evidence of it. So to answer the court's question, of course we have asked who spoke to whom. Did Tracy Lewis, did you speak to Adrian Bean? Tracy Lewis, I talked to Walter Murphy, and I put it in my report. I made a report of that. Calhoun, did you talk to Adrian Bean? I talked to Frederick Prothro. Here's my recording of that. Detective Quinn, and then this idea of destruction of evidence, that is the fallacy that is getting thrown around. That's the problem with asserting facts not in evidence. That's the problem with them being allowed to ask those kind of questions. Do you destroy evidence? Nobody has said anyone destroyed any evidence. Eduardo Navarro Flores said he heard that Detective Quinn had erased the interview. Well, then why all throughout Detective Quinn's report does he refer to the lie that Eduardo told in the first place? How is that destroying evidence? But they're trying to create a narrative for the jury of things that don't exist, a narrative that somehow the state destroys evidence. There's been no evidence, no suggestion that the state has destroyed any evidence, but they're going to ask it a million times. So that's what Mr. Steele is doing with this whole statement at the hospital. He's going to ask it a million times. So the jury's sitting there going, well, where is it? And then in the end, $100 says that he gets up there and says, they destroyed the statement from the hospital, knowing he has no evidence that one even exists. With Detective Lewis, and certainly not Detective Quinn, who is the only person Adrian Bean tells Mr. Steele, at least in the portion of the recorded interview he gave me. I don't know what else he told. I don't know what Mr. Steele told Adrian Bean. But it's obvious that he's leading him through the interview that the court heard. And even being led, Adrian Bean does not let up on his assertion about Detective Quinn. Mr. Steele tries to get him to change it. You mean somebody else, other police, no, just Detective Quinn. So this idea that he has a right to ask questions.
So tired of them. I really am. I am so tired of them. I really am.
Did you tell the police there's some recording that Jeffrey Williams was involved in this armed robbery because the police told you to say that so you can get out of trouble? Is that the reason? Yeah. Okay. Now you're also on another show called The One I'm going to send you. That's the one I want to hear. I'm going to send it to you. But when you say the reason you would have.
So, Your Honor, when Mr. Steele says, do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing police officer Roberson L. and striking the other police officers and careening over the embankment into the wall and fleeing? Do you remember that? He says, no, sir. Then the question, do you remember telling that detective, specifically Detective Lewis, at that time, there were 3 people in the Nissan Red Altima vehicle? That's nowhere in this statement. What what Mr. Bean is doing at the point that the court just heard, he's saying one thing, and then he's saying, you know,
But
the hospital over there. We were like victims.
but the thing is that it's not Mr. Steele fault if this boy stand out on the line. We already knew he was lying. When he was on the stand, when he testified, we knew that boy, Mr. Bean, was lying the whole time. Ain't no way in the world he can't remember nothing. Indeed, he lied to Mr. Steele. I don't remember. I don't recall. He don't keep act like he lied, man. That boy lied the whole time up on the stand.
On this day, instead he just jumps right to, why'd you lie to the police? Those things are not proper. There's a way to do things, and he has not done them the proper way because he wants to put in the jury's mind facts that don't exist. And that is not the way a trial is done. It's not the way you get at the truth.
But that ain't Mr. Steele's fault, though.
And that's what he's done.
Okay. All right. Anything further, Mr. Steele?
I have absolutely nothing to say unless the court wants me to say something. There's a continuation of the rants of
And Your Honor,
I didn't ask anybody to laugh in the gallery, okay? This is a courtroom, not some entertainment forum for you.
Thank you.
Yes.
the insults again, if they're gonna be called rants, I think we should recognize what we're doing. When we stand up and go on and on with his spirits, as Mr. Steele has done, I'd ask that he be precluded from slaying insults.
Well, both of you took professional responsibility when you were in law school, and that's not the way that we treat each other as professional colleagues.
That's right.
I'll just leave you with that. All right.
I do one thing.
No, I'm going to let I think I've been asked to take a comfort break, so I'm going to let everybody take comfort, and then I'll figure out what to do for the rest of the time. Okay.
All right, y'all. I'm gonna tell you like this. I'm gonna put it on the table. It was day 42. Adrian stood on that stand and testified and lied. And we knew Adrian was lying. Well, not Adrian. What his name, Bean. We knew when he said, I don't remember. I don't recall. I did. We were sitting up there saying to ourselves, now he can remember something. That boy lied when he was on the stand. Y'all like, share, and subscribe. I'm out of here.